We are now going to discuss the Probation Law, or Presidential Decree number 968 as amended. What is probation? Probation is a disposition under which the defendant, after conviction, is released and allowed to serve his sentence outside of prison, subject to the conditions imposed by the court and to the supervision by a probation officer. So take note that there must be a conviction first before probation can set in. Also take note that the nature of a probation is that it is a mere privilege. It is not a right granted by the state to qualified offenders who admit their liability and renounce their right to appeal. In view of their acceptance of their fate and willingness to be reformed, the state affords them a chance to avoid the stigma of an incarceration by making them undergo rehabilitation outside of prison. What are the objectives of probation? First, rehabilitation and correction of the accused through individualized treatment. Second, to give better chances for a repentant criminal to reform. Third, prevent further commission of crimes as the criminal is placed under the probation officer's supervision. Fourth, one of the objectives is to decongest the jails, because once a criminal or a convict is granted probation, he will not be imprisoned. And save the government from spending money for maintaining the accused in prison. Now, what is the probationable penalty? A convict who is sentenced to imprisonment of 6 years or less may apply for probation. Take note of that. It is only when a convict is sentenced to imprisonment of 6 years and below may he or can he apply for probation. Those imposed a penalty of fine may also apply for probation, provided that the judgment of conviction states that, and I quote, the offender shall suffer the subsidiary penalty of imprisonment in case of insolvency to pay the fine, or words to that effect. Who are disqualified to apply for probation? Number one, those whose prison terms exceed 6 years. Number two, those convicted of subversion or any crime against the national security or any crime against the public order. Third, those who were previously convicted of a crime punishable by at least 1 month and 1 day and or a fine of at least 200 pesos. Now, let me explain this third disqualification by way of example. Example number 1. X was convicted of a crime punishable by 4 years imprisonment. So, readily you can see that the penalty is probationable. However, previously, he was convicted of another crime punishable by 6 months imprisonment. In this situation, he is disqualified to apply for probation with respect to the 4 years imprisonment because he already had a previous conviction of which he was sentenced to a penalty of imprisonment of at least 1 month and 1 day. And the same is true if the conviction imposed a penalty of fine of at least 200 pesos. Let's go to example number 2. X was convicted of a crime punishable by 4 years imprisonment. However, previously, he was convicted of another crime punishable by 1 month imprisonment. This time, he is qualified to apply for probation with respect to the 4 years imprisonment because his previous conviction only had a penalty of 1 month imprisonment. The same is true if the penalty of fine is less than 200 pesos. Fourth, those who were once recipients of probation. Why? Because probation can be granted only once, meaning to say if you have already applied and was granted probation, you can no longer avail of the benefits of a second probation. Fifth, those who have perfected an appeal from a judgment of conviction of a probationable penalty. Why? Because appeal and probation are mutually exclusive remedies. Once you have perfected an appeal, you can no longer apply for probation, or once you have applied for probation, you can no longer appeal your conviction. However, if a judgment of conviction imposing a non-probationable penalty is appealed or reviewed, and such judgment is modified through the imposition of a probationable penalty, then the convict shall be allowed to apply for probation before such modified judgment becomes final. This is the amendment made by Republic Act 10707. So, this contemplates of a situation where the judgment of conviction imposed a non-probationable penalty, let's say more than 6 years. And the accused appealed his conviction. And because of the appeal was in his favor, so much so that the judgment convicting him was modified, and this time it imposed a probationable penalty. Let's say the penalty was lowered to 5 years. In such a case, the convict shall be allowed to apply for probation. And last of the disqualifications is if the special law prohibits offenders from applying for probation even if the penalty imposed is 6 years or less. So, it depends on the special law concerned. If the special law itself expressly prohibits offenders from applying for probation, then that law or provision prevails. When shall the application for probation be filed? It must be filed within 15 days from the promulgation of the judgment of conviction. Otherwise, the judgment becomes final after the lapse of 15 days and the application for probation will no longer be entertained. A judgment is promulgated by reading it in the presence of the accused and the judge. If the accused fails to appear despite notice, it shall be promulgated by recording the judgment in the docket and serving a copy thereof at his last known address or through his counsel. Now, if the convict chooses to appeal his conviction and such appeal has been perfected, he can no longer file an application for probation. This is what I explained a while ago, because the two remedies are mutually exclusive. Take note also that an appeal in criminal cases is perfected by filing a notice of appeal with a court which rendered the judgment and by serving a copy thereof upon the adverse party. On the other hand, the filing of such application shall be deemed a waiver of the right to appeal the conviction. Reason? The two remedies, to repeat, are mutually exclusive. However, if the convict seeks the review of or appeals the judgment of conviction imposing a non-probationable penalty, this has been emphasized in the previous slide, and such judgment is modified through the imposition of a probationable penalty, the convict shall be allowed to apply for probation based on that modified judgment before such judgment becomes final. When does a judgment become final? Number one, it becomes final after the lapse of the period for perfecting an appeal. The period here refers to the 15-day period from the promulgation of the judgment of conviction. Second, it becomes final when the accused waives his right to appeal. Third, a judgment becomes final upon the grant of a withdrawal of an appeal. So here, the accused initially files a notice of appeal, but later on he changed his mind and filed a motion to withdraw his appeal. The court accordingly granted the withdrawal, and upon such grant, the judgment shall become final. Fourth, a judgment becomes final when the sentence has already been partially or totally served. Or, a judgment becomes final when the accused applies for probation. So, this emphasizes the statement I made a while ago that the two remedies, probation and appeal, are mutually exclusive remedies, meaning to say the availment of one will result in the waiver of the other. Where shall the application be filed? It shall be filed in the same trial court that convicted and sentenced the accused. The application based on the modified judgment shall also be filed in the same trial court that convicted and sentenced the accused to a non-probationable penalty. Lastly, will the application for probation be granted automatically? The answer is no. Even if the convict possesses none of the disqualifications under Section 9, he must still meet the criteria in Section 8 of the Probation Law. Hence, if the court finds that he is in need of correctional treatment, or there is undue risk that during the period of probation, the offender will commit another crime, or the probation will depreciate the seriousness of the offense committed, he will be denied probation.